All right, guys, welcome to a very special episode of The Left Wing. We are here to discuss the Trump trial and kind of refute a lot of the arguments that have been being made by Republicans and conservative media pundits across the board. Now, I did a little bit of research on this. However, I am not a lawyer. So, in order to help fill in my gaps of knowledge, we have the leftist lawyer here, attorney Sheryl Weikal. Sheryl, how about you tell our audience, what it is that you do?
Thank you so much for having me. My name is Sheryl Weikal. I am a name your own price trial lawyer. I run a name your own price law practice for people facing incarceration, eviction, foreclosure, and discrimination in all 102 counties in Illinois. Illinois is one of 42 states that charges for and means tests the public defender. So I take cases for people who cannot afford the public defender. I also represent people who can't afford lawyers where there is no right to counsel. There is no right to counsel in civil cases in Illinois, so eviction cases, foreclosure cases, discrimination cases. And I'm a trial lawyer, so I take cases to trial where necessary.
That is wonderful. It is such a shame that people like you are a necessary part of our legal system, but without you, so many people would, be railroaded by things they really shouldn't be. So very much appreciate everything that you do in that part of your life. Now let's do something slightly more fun and make a YouTube video, shall we?
Absolutely. Thank you so much for having me.
All right. So wanted to get into this. So one of the biggest, I don't know, talking points that Republicans and conservative media pundits have been using is that this is a total political witch hunt. That like if Donald Trump wasn't running for president, he wouldn't be on trial for these crimes. Is there any sort of grain of truth to that at all, or is there precedent for this kind of case?
I have mixed feelings whenever I hear conservatives say that this is proof of a two-tier justice system, because the truth is it is, but not in the way they think. So I'm someone who represents a lot of people who are charged or accused of what I call crimes of poverty. Shoplifting, toll violations, the evictions can turn into criminal charges, being stopped for driving while black, that kind of thing. And what I find interesting is how often uh, the, the basic civil rights that people take for granted are not given to socioeconomically disadvantaged people, as opposed to the privileges that Mr. Trump is receiving over and over and over again. As just one example, Mr. Trump violated the gag order in his case on multiple occasions, and the worst thing that happened to him was he got a talking to from the judge and a small fine. I once had a client who was sentenced to 6 months in jail for violating a gag order the first time. And although I was eventually able to get that order reconsidered, I think just that disparity shows the kind of kid gloves that Mr. Trump has been treated with this entire time. The fact that he has the best defense that money can buy in a case where I have represented people charged with a similar level of crime here in Illinois where they were denied the public defender because they were told they make too much money because they own their own home, or they work full time so they can't have the public defender. And they were just told represent yourself. So as much as it is definitely true that there is a two-tier legal system, it is also true that rarely will you see someone convicted of 34 felonies and then walk out of the courtroom afterwards. Usually, at least in my experience, when someone is convicted of even a low-level felony, their bail is revoked, their pretrial release is canceled, and they are remanded. And I've seen that over and over and over again. So it is I don't really have much sympathy for the argument that this is proof that he is being treated differently. He is being treated differently, just much better. The other side of that coin is the idea that he is unprecedented in that he is the first former president to be convicted of a crime. Um, and that is interesting to me because there are so many of his predecessors who have committed really heinous crimes that were just never charged. One of the interesting aspects of Trump's cases has been an exchange that occurred between his lawyers and a couple of the Supreme Court justices in his presidential immunity case, when the colloquy, what we call in the law an exchange, the colloquy was about whether um, FDR's order to intern Asian Americans in concentration camps would lead to criminal charges if there were not presidential immunity. And I think that was a good reminder of the kind of monstrous crimes that occupiers of that office have committed that have just never been charged.
Hmm.
So, as much as, yes, it is unprecedented that a president will be charged with something, or a former president, it is not in any way unprecedented for a president to commit a heinous crime.
Hmm.
It is simply unprecedented for anything to be done about it. And I think that it is also somewhat problematic that of all of the things that Mr. Trump did as president, for this to be the thing that leads to 34 convictions, not his Muslim ban, not the overt support for literal white supremacists, not the repeated illegal acts at the southern border. Um, it's this. And it is not to say that this law is less important than any other, but I think there is a almost an expectation that it is okay for a president to commit crimes as long as they're against an acceptable group of people.
Hmm.
And that sort of dichotomy has been underlying a lot of the commentary about this trial, the other charges that he is facing. And I will be honest, that bothers me more than a little bit, especially given the previous dichotomy in treatment between him and people who are not quite so fortunate.
Yeah, I think you hit the nail on the head there because it is a two-tier justice. We've said that multiple times on this show that like we've said that exact same thing. But the interesting part, like Trump is saying, oh, I'm totally going to go after my political opponents now, and it's like, so one of either two things is true. Either you think that your political opponents have done legitimate crimes, and now that you've been tried for a legitimate crime, you're going to try them too, which is fine, but you're admitting you committed a legitimate crime in that case, or you're going after them for crimes they didn't commit, like you're saying that you didn't. So, like, there really is no way to look at this that doesn't make Trump look extremely bad. Even if, like, he was president, is he telling us that he wasn't going after, political opponents who actually committed crimes? I fail to believe that he actually wouldn't have done that if there was opportunity to do so. But you're right. There's been a plethora of crimes committed, heinous crimes, far more heinous crimes than this, committed by many presidents throughout our history that unfortunately were never tried. They were never convicted. But I'm glad at least someone is starting to be held accountable. And hopefully this starts a trend.
I hope it does, but I will be honest, I'm not holding my breath. I am. There is, whenever you walk into any courtroom, and
Mhm.
oftentimes I think this happens without even the players involved understanding. There is very much a difference in expectation between how different kinds of courtrooms operate. And to give you a great example, I don't know if you have ever recommended to your viewers the work of Matthew Desmond, who has done just fantastic research on the impact of evictions across the country. But if you go into any eviction courtroom, anywhere in the country, you're going to see largely white landlords and largely black and brown tenants. And that's by design from the eviction statutes, every one of which is a literal Jim Crow law. You look at how a lot of misdemeanor statutes have been enacted, it is very much the same thing. And then you go into courtrooms where you're dealing with more quote unquote white collar criminals, and you see a very different way that certain defendants are treated, which is not to say the that every person participating in the system is necessarily signing up for that, but it is nonetheless true that the system as it exists today incentivizes recidivism. And to put that in a different way, we have, and this is largely the result of the quote unquote tough on crime rhetoric of people like Mr. Trump, we have made it essentially impossible for people to become reincorporated into society after incarceration. You basically, when you get out, you can't get a job because of criminal background checks. You can't get housing because of criminal background checks. And they don't give you any money when you leave because most of jail and prison labor is either unpaid or you are paid pennies per hour. The end result is I have had clients who have been subject to prosecution for petty theft for stealing food because it was the only way they can survive. I have had clients who have said that their choices were starving or going back to jail. I have
Mm-hmm.
had clients where they were incarcerated in a facility that refused to release them even when their time was served because the facility was using them for labor and the company needed those bodies.
Mm-hmm.
So this is that is the kind of system that people like Mr. Trump have created and that he is almost certain to avoid. And the problem is, as much as I am a carceral abolitionist, I believe the entire system has to be abolished. I don't think that's going to happen until and unless the people who created it start to see or experience the consequences that they mete out on other people.
Mm-hmm.
It is not that I believe that anyone deserves the kind of conditions that we currently impose on people in prisons and jails in the United States. But I also think that it would not be a bad thing if the powerful, if the people who think that the conditions that are experienced in our jails and prisons are a good thing because the offenders, quote unquote, deserve it. I think that it would not necessarily be a bad thing if those powerful people did have to experience what they were putting fellow human beings through. Because I'll tell you, the vast majority of people who I have encountered in jails and prisons have been good and decent people. And I know that is surprising to people, but it goes hand in hand with the glee that unfortunately I see a lot of liberals displaying over Trump is now a convicted felon. There are a lot of people who are convicted felons who are good and decent and honest and hardworking people who were caught up in racialized policing
Mm-hmm.
or who pleaded out because that was the best deal they could get or for a lot of reasons now have a felony conviction for even a non-violent crime, and as a result, they are stuck with that stigma for the rest of their lives. The mere fact of being a convicted felon does not make you a bad person. And I do not like legitimizing that stigma in any way. Mr. Trump is a terrible person because he's a white supremacist, because he's a fascist, and because he shows no empathy whatsoever for anyone around him, and because he is a serial sexual predator.
Mm-hmm.
He is not a bad person because he is now a convicted felon. There are thousands, tens of thousands of convicted felons across this country who are good and honest people, who are better people than Mr. Trump ever will be. And that would be true if he had been convicted or not. So I was hopeful that this would trigger somewhat of a reframing of how we as a society look at and talk about the criminal legal system, which I will never call the justice system. But I have not seen that yet, unfortunately. I have seen people who believe this is proof the system somehow works when it is very much not. I have seen people saying, well, maybe this is proof that there will start to be consequences, when in reality, I agree with most observers. The court was reticent to if the court is reticent to enforce its gag orders, the court will be reticent to sentence Mr. Trump to incarceration. I think probation is the most he's going to get. So no, I don't think this is unfortunately the start of a new era of accountability. If anything, it is a continuation of the previous trend of a lack of accountability. The only difference between Mr. Trump and a myriad of other presidents who have committed heinous crimes is that he's so much worse at it.
That's it's so funny, Cheryl, because I promise to our audience who watches every single time that we talk about this, we didn't discuss this beforehand. She's just arriving at the same conclusions that we are, because so many of those things that you just said are exactly what we've been talking about, that no other person would have survived that many that what he was held in contempt, what, like a dozen times or something like
Yes.
that. Like no one else would have not been, sent to jail because of that. From the top down, he has been treated with kid gloves. And even from the most, I like how you brought up how our our penal system is often overly penal, overly penalizing, overly brutal, and focuses on punishing evildoers more than it does rehabilitating people so they become better members of society. And if more of our leaders kind of experience those conditions, maybe it would change some things a little bit faster because, even from a, I know legality isn't morality, but ideally we would like our legal system to reflect some code of moral ethics. And I feel like it's a pretty basic moral principle that you shouldn't give someone a punishment you wouldn't be willing to take yourself for the same crimes, which is why when I see Trump like just so blatantly just claiming that he shouldn't be held accountable for crimes that he would punish people for, it blows my mind how normal everyday Americans see that and don't just hold that in contempt. But oh well, it blows my mind a lot of things that normal everyday Americans will do in relation to Trump. So that is the case. I wanted to pick your brain about a couple more of the legal questions of this case that have come up. One of which that did actually, I don't blame Republicans for kind of being confused by this because I was also confused when I heard about it. There's been a lot of talk about the requirements for a unanimous decision, how a lot of Republicans have said, oh, the judge told the jury that they don't actually need to have a unanimous decision. They could vote 4-4-4 and they'd still convict. Are you aware of the arguments about that? Could you enlighten our audience about, how there's maybe a little bit of a grain of truth to that, but it doesn't mean what the pundits are saying it does.
So let's start with how jury instructions actually work. So as somebody who's actually done jury trials, and I'm licensed in Illinois, not New York, but there's not that much of a difference on this particular issue. Most of what the judge is telling the jury has been has been at least vetted or supplied in some way by the lawyers. And let me explain what I mean by that. Before the trial ever begins, at what is called a pretrial conference, the lawyers for the two sides, in this case, the prosecution and the defense, will have copies of what are called jury instructions. Usually there are pattern jury instructions that the state court provides for certain cases, and those are recommended. Sometimes you'll tweak the language a little bit depending on what the offenses charged are, and sometimes you'll have what are called non-pattern instructions. And the instructions are just restatements of relevant law. The judge can say, yes, I'm going to read this instruction. No, I'm not going to read this instruction. Sometimes it's a mix of the two sets. Sometimes it's one set or the other. And oftentimes where there is a reversal on appeal, it is because of how the judge instructed the jury. In other words, which set of jury instructions the judge picked. Now, this, as far as whether or not a jury verdict must be unanimous, here is the thing. If there are 34 charges, that means that there are technically 34 verdicts. What that means is that the jury has to reach a separate verdict 34 times. And what the judge was attempting to explain was that if you reach a different verdict on a couple of these counts, that doesn't mean you can't convict on any of them because you're basically reaching 34 verdicts. Now, typically speaking, the jury has to be unanimous. And there is case law on this, especially in non-civil cases. And there's a whole bunch of case law out there on whether or not state law and the Constitution allows for non-unanimous jury verdicts. And that is why at the end of a trial, you are allowed to what is called poll the jury. You could say, is this your verdict? Is this your verdict? To make sure everybody is on board with the verdict that came back. And it seems here this was a unanimous verdict. I did not personally think that at any point the court instructed the jury, you don't have to be unanimous. If four of you think that this is fine, it's fine. I think what he was attempting to explain, based on the jury instructions that were provided to the jury, I think he was attempting to explain, okay, you can disagree with each other overall on different counts, but you have to agree with each other on each individual verdict. And frankly, I think some of what is coming out of the interpretation of those rulings is intentionally misleading, designed to make people think that this was somehow, as Mr. Trump keeps saying, a quote unquote rigged trial. Frankly, it sort of ignores the fact that the Mr. Trump's own lawyers had a hand in the jury instructions that were provided to the jury. And in interviews, his attorneys have complimented the jury on their studiousness, on the fact that they took notes, that they requested to hear evidence again. Juries do try very hard to get it right. They really do. If this is overturned on appeal, I think it's more likely going to be because of one of the evidentiary rulings that the court made, and not necessarily because of some defect in jury instructions. I could be wrong, though. It does happen all the time.
Yeah, and I certainly wouldn't give my own legal opinion there because it is completely worthless, compared to yours. So I'm going to just trust what you have to say there. But there was one, the unanimous decision one. I was a little confused, but when I read about it more, it made perfect sense, just like you just explained. There was one legal argument being made that I thought might have a little bit more legs to it. And that was the one involving, essentially, for those who haven't looked too much into this case, it wasn't just that he paid off Stormy Daniels. It's that he paid off several people actually, but not that he did that, but he used campaign funds to do so, illegal campaign funds that were illegally contributed to his campaign, and then he lied on business records to cover up that crime. And that is the reason that this is being charged as a felony, and not a misdemeanor or some lower violation. I'm correct about that, right, Cheryl?
So basically, the biggest difference between a felony and a misdemeanor is the length of time of the sentence of incarceration as a result of a conviction. Generally speaking, if it's less than a year, 364 days or less as the maximum penalty, it's a misdemeanor. If it's 366 days or more, it's a felony. That is generally the difference. Every so often, you'll see an oddity, but that general rule is going to have you write 999 times out of 1,000. Now, here is what he's charged with: falsification of business records. One thing that Mr. Trump's defenders have been saying that is correct is that under New York law, it is not illegal to pay someone to not talk. And in theory, that is all an NDA is. People, you hear non-disclosure agreements all the time. I prefer confidentiality provision because that strictly speaking is more accurate. But that is fairly common in certain settlement discussions. It's fairly common depending on the nature of a court proceeding. What is not common, what is not legal, is to call it something else. If you and someone else are involved in a lawsuit and there is a confidentiality provision as part of that settlement, you cannot, when you receive that money, you cannot say that you received the money for, so that because it was a bribe for you to go and do this other thing. You still have to be honest about what the money was for. And that's actually why, if you look at most confidentiality provisions, there is language in there that says, at least if it's well drafted, you can still be honest with your tax preparer, your attorney, medical providers, people who have to know the truth about where this money is coming from and what it's for. So the key here is not the payment itself. The key here is that it was recorded as, for example, legal fees, when it was not legal fees. The money did not go to Michael Cohen as legal fees. That is the big issue here, that he usually basically made a payment for a confidentiality agreement and called it something else on a business record. So, and that is the essence really of white collar financial fraud. That's the kind of crime that we're talking about. It is the kind of an offense that happens when you falsify a business record. It is the circumstances around it make it a little more salacious than your average financial fraud crime, but that is essentially what you're talking about. Somebody said that this money was for purpose A when it was actually for purpose B. If he had put on the check and in his records settlement with Stormy Daniels, it probably would have been entirely legal.
Mm-hmm. Yeah, yeah, probably. But if he had done that, then, well, people would have found out about it, and that might have hurt his election chances, especially so close to the election, which is why, I think one of the other arguments that's often tossed out about this is, oh, this doesn't matter. This is just boring legal jargon. It's not really a big deal, and Democrats are making a massive deal out of this because it's a political witch hunt, which is utterly absurd. Because while I agree of all of the things he's being charged for, this is probably the one I care about the least personally. Like he's being charged for much worse stuff in other states and from the federal cases as well. This is very important because when you talk about white collar crime, it's not that the victim is necessarily the person being directly involved in it. It's the entire system is victimized by white collar crime. That if you falsify these business records, they were legally required to be that way for a reason, so that people would have insight into what is going on in business dealings that are supposed to be public. And if we don't, and one of those people runs for president and ends up winning an election which would have been decided by less than 100,000 votes, well, suddenly that changes the course of history because that law was broken. So no, that's a potentially very important thing. So, Cheryl, I also want to pick your brain about another facet of this case that I think has caused a little bit of confusion. So one of the big parts, as we discussed, is that we need to connect the New York state law to the federal campaign finance laws. And several Republicans have come out and gone and said that this is just the New York prosecutors trying to make up a crime that, doesn't really exist, when that's not really true. However, we have had people such as former FEC Chairman Brad Smith say that the campaign finance laws in question in this case weren't actually crimes, that Trump had not used campaign funds in order to pay off Stormy Daniels and others in this case. And so the falsification of business records were therefore not to conceal a crime. So I was wondering if you could speak a little bit to that, why this might be causing confusion for people, and why people who are saying that, it isn't true that he violated any campaign finance reform laws aren't really being completely honest about their assessment of the case.
So this, I think, goes to one area in which we as sort of legal educators have kind of failed to explain things clearly. There is a difference between what Mr. Trump is alleged to have done in New York and what he has now been convicted of doing in New York, and what he may or may not have done with respect to campaign finance laws, which are federal laws. You can violate a federal campaign law without violating a New York records law, and you can violate a New York records law without violating a federal campaign law. Whether or not there was an underlying crime does not change your independent duty to be honest on your business records in New York. And therefore a false statement in a business record is a crime, whether or not an underlying crime existed. So that is not actually grounds for a not convicting Mr. Trump or a reversal of a conviction of Mr. Trump, because the New York law, what it prohibits is falsifying business records. So that crime, and every time we talk about a crime from a legal perspective, we talk about what we call elements. Each individual component you have to do in order to actually complete the crime. So the elements of that crime are complete when you have a business record that you submit as a real business record that is knowingly inaccurate. So it doesn't matter where the money came from or whether or not it was a violation of campaign finance law. It only matters if he submitted an inaccurate business record on purpose. That's the crime in New York. Campaign finance law is something else. So it is entirely possible to do something that is legal under campaign finance law and not legal under New York business record statutes. And so I think that it really is discussing apples and oranges. That it, even whether or not it's true that what he did doesn't violate campaign finance law, you're still not allowed to make false statements in your business records in New York.
So even if it's later litigated and it comes out that this was not any violation of campaign finance law, he still committed the crime of falsifying the documents. Like, he is still a convicted criminal.
Correct. And Lanny Davis, who previously represented Michael Cohen, made this point on NPR a while back, and I think it's a very good one. The crime was complete when he said that money that he was paying to Michael Cohen for legal fees was actually paid to Stormy Daniels as a consideration for the confidentiality agreement. That's the crime. When you say, okay, I am writing down in my business records that I'm paying $130,000 to Michael Cohen as legal fees, and I'm not giving that money to Michael Cohen as legal fees. That in and of itself is the crime.
No, that's a great explanation. Before we wrap this up, I had one more question that I wanted to ask about, and that is the judge having given donations to President Biden as well as general Democratic. I think there was a couple PACs in there that he gave to. Now, these donations were a very marginally small amount. I believe it was $35 total, $15 specifically to the Biden campaign. And now, you can think what you want about that, but could you speak? Is there, in your experience, judges having given money to political campaigns in the past that might have some bearing on the case? Is that something that has never happened before? Is that something that does happen? Is there some sort of legal process that judges go through in order to make sure that everything is ethically sound? Can you speak a little bit more towards that objection that I've been seeing going around?
Sure. So I will be honest. If I had my druthers, judges would not accept or give campaigns to any political candidates, or anyone for that matter, just because I think the appearance of impartiality is extremely important. And I talk about this at some length in my book. It's called Circus Courts. It's available on Amazon. But if you're in a state like Illinois, for example, where all state court judges are basically elected, you see a lot of law firms making donations to the campaigns of judges and then having their cases heard by those judges that they just made donations to. In fact, there was a pretty famous Supreme Court case from the mid-2000s where the West Virginia Supreme Court decided a case that concerned a major donor to their campaigns about the propriety of that donation. So, and the U.S. Supreme Court ended up saying that that's a bit of a due process problem. But of course, this was before we learned about the various gifts that are given to Clarence Thomas. The bigger issue I have is that we're talking about this, and this is true of people on both sides of this dispute. We're talking about whether or not it is acceptable for a judge to make campaign contributions, should he have to recuse himself, et cetera, without looking at this in the broader context of what is acceptable for a jurist in the American legal system when it comes to political advocacy and accepting political donations. Because right now, we have a system where making and receiving donations is, especially at the state court level, pretty par for the course. There are, like I said, in Illinois, there are law firms that make very large, much larger than what was donated to the court here, or donated by the court here to the Biden campaign. And then those same donors appear in front of the court. And generally speaking, the mere existence of a donation, I think it should be enough for there to be the appearance of impropriety. But I think this goes to some of the broader issues that this case has brought to the fore that we are not acknowledging or that we are accepting without contesting. Um, First of all, I think there should be stricter standards when it comes to the recusal standards for judges at every level. Do I think that under current law, um, Judge Marchand did anything wrong? No. Do I think that we should have a standard that says if you donate to a candidate's opponent, you should recuse yourself? Yes, I actually do. Because I think I think it is important to have that appearance of impartiality at all levels. The same thing with the confidentiality agreement itself. Um, we've been talking about the falsification of records and the impact of the election, but for years, the legal profession has accepted without deciding that it is okay for confidentiality provisions for NDAs to be signed in claims of sexual misconduct, in claims of sexual harassment. And it is now essentially considered an understood material term of settlement agreements. It doesn't have to be. And so I feel like what this case has done in some ways is shine a light on issues that the legal profession has just decided, well, this is how things work. And what concerns me is when I see defenses of the system based on that. What I might, and this is my personal belief here, but we saw this a little bit during the last election cycle when Michael Bloomberg joined the race, and he had a series of sexual harassment complaints that he settled, and those agreements included confidentiality proceedings. And Elizabeth Warren called him out for it at one of the last debates. And the problem, I think, is that we have not advanced our discourse much beyond that. And if anything, we've gone backwards because instead of recognizing the inherent power disparity that must be necessary for a presidential candidate to silence a potential accuser for $100,000, we are talking and snickering about hush money paid to a porn star. We are not talking about the inherent impropriety in how our judges, and from the Supreme Court down to the trial courts, how our judges make decisions on whether or not to recuse themselves. We're talking about whether small donations really matter in the abstract. And yes, under the current rules, nothing that the court did was in any way improper or incorrect. But I think that the current rules leave a great deal to be desired. And yes, I do think it is a good thing that Mr. Trump was convicted. I don't think that his conviction should be overturned on that basis. I don't think that in any way the court was unfair to him. The court treated him with kid gloves the entire time, as we've discussed. But I don't think that a system where you can donate to someone's opponent and then preside over that trial is a system that is functioning the way it should or could be. And this is not in any way a defense of Donald Trump. This is simply saying this is symptomatic of much larger issues within the system that we are, for better or worse, simply not talking about in this broader discussion.
Yeah, and I think you make a really good point there that just because something is legal doesn't mean that we have to agree it's right, but it is the law that we do have to abide by. And to kind of bring it back to the original refutation that Trump was making, it's completely contradictory. You know, his assertion that this is unprecedented and therefore it shouldn't be allowed to happen is directly contradictory to the judge making a small legal donation, a small donation to a campaign, which is totally precedented and totally allowed. And we might agree with Trump, you know, a broken clock is right twice a day. Yeah, maybe that shouldn't be legal, but it is. That is the precedent. So you can't have your cake and eat it too, where you want things to be done by the book, but also you think special exceptions should be made because this is an unprecedented circumstance. So I really like how you put that, Cheryl. I have a lot of respect for people who will call out problems with the system, even when the system benefits their position. I think that is a sign of someone who thinks critically about these subjects. And as a lawyer, I'm sure you have to think critically all the time. Let's wrap this up because I know you don't have too much more time here. If our viewers wanted to find you on social media, where should they look?
So you can find me in a few places. My Threads handle is the Leftist Lawyer. You can also find me on Instagram, same handle, the Leftist Lawyer. You can visit me online. My website is www.weikallaw.com. That's Weikal law.com. You can also email me, Cheryl@weikallaw.com. And if you like my content, if you want to read some articles that I write about my travels throughout the Illinois legal system, my thoughts on legal issues of the day, you can visit my Patreon. It is Cheryl Ring Law.
Awesome. Well, thank you very much for joining us, Cheryl. Hopefully, there will be several more convictions in the future that we can bring you back on to discuss. But thank you very much for being here. And to our audience, thank you. Make sure to like and subscribe and go follow Cheryl. She is an excellent follow, especially on Thread. So have a good day, everyone.